Application to challenge the Home Affairs Minister's decision to terminate the ZIF by the Zimbabwe Immigration Federation may see a settlement between the two parties.
Perhaps to give an update to the court, there is an attempt to settle the case, but I'm not at liberty to disclose the proposed settlement at this stage. But we are unable to finalize it because neither the DG nor the minister is available to give instructions to my learned friends. We've agreed that we will press ahead with the case. If it does get settled, the court will be informed so that you are saved from the process of judgment writing. If it happens during the course of this afternoon, you will also be informed.
Toby is representing 1,000 Zimbabwean nationals under the Zimbabwe Immigration Federation who will be adversely impacted by the termination of the ZIF. The ZIF is a special permit issued in terms of the Immigration Act that currently allows almost 180,000 ZIF holders and their dependents temporary legal status to live, work and study in South Africa. This was in response to the influx of Zimbabweans fleeing from political violence in 2008. Toby argued that the ZIF holders would suffer irreparable harm should the Department of Home Affairs terminate the program.
The question is, on the 1st of July 2023, what will happen to the 178,000 recipients of the ZIF program? What will happen to them? It is common cause on the fact that they will be rendered overnight, they will be rendered illegal immigrants in South Africa. That would mean either they deport themselves voluntarily, but the facts show that they are unable to return to Zimbabwe for the reasons that would be articulated. What would then mean is that they would be liable to deportation, forced deportation. Alternatively, they would be liable to arrest because they would have violated the provisions of the Act.
Toby further submitted that the Home Affairs Minister used the incorrect legislation to affect his decision, arguing that the ZIF could only be withdrawn with justifications that laid the foundation for its introduction in 2009.
The primary justification why the DZP, later to be called the ZIF scheme, was introduced was precisely because of the declining economic and political situation in Zimbabwe. That means that it can only be withdrawn for reasons that are related to the economic and political instability in Zimbabwe. What we have here is a constellation or a random assemblage of justifications that have no bearing to the justification for introducing the scheme in the first place.
Advocate Sean Rosenberg, on behalf of the minister, argued that the holders of the ZIF should have taken appropriate action in anticipation of the expiry of the temporary program.
A 4-year program where the permits have, to everybody's knowledge, been of temporary duration, and every single one of those permit holders would, not only should, would have been aware that on the 31st of December 2021, those permits were to expire. And it's not unreasonable to expect the beneficiaries of those rights to act accordingly and, if needs be, to take appropriate action timeously.
The matter continues on Friday with a third application from African Amity and 29 ZIF holders. Canny, Maphanga, SABC News.